The Constitutional Court will hear former President Jacob Zuma's state capture contempt case on the 25th of March. That is. Last month, the inquiry filed an application asking the court to jail Zuma for 2 years. This is for refusing to testify, despite a court order compelling him to do so. Joining us for more on the story is the University of Cape Town's Public Law Associate Professor Kathy Powell. Kathy, good evening, and thank you so much for your time then tonight. What are the options that lie next for the former president? If history is anything to go by, at least with the matters at the Constitutional Court, what happens if he decides not to send any legal representation?
Well, as you noted, that's what he did last time. He did not appear to argue his own case at all when the Commission took their case against him to the Constitutional Court to get the first order that he's now disobeyed. If he doesn't turn up, the Constitutional Court can still reach a conclusion, just like it did the first time. What will happen is it won't get the benefit of the defense argument, so to speak. So the applicant is the Zondo Commission. They've set out a 226-page case explaining what the problem is, why they think there's contempt of court, and why they think imprisonment of 2 years is the appropriate sentence. Now, that is what Zuma, as the respondent, is meant to respond to. He's meant to say either no, it wasn't contempt of court, or all right, yes, it was contempt of court, but it doesn't deserve that kind of punishment. If Zuma just doesn't pitch like he did last time, then the court has to make up its mind without his help. Now, it's interesting that last time the court made up its mind without his help, he immediately accused the court of bias, and he accused the court of being politicized. One of the things he kept saying was that he should not be summoned by the Zondo Commission until his review application against Zondo's refusal to recuse himself is heard and decided. Now, that's something he could have said to the Constitutional Court but didn't. So if he carries on like he's been doing so far, he won't turn up. The Constitutional Court will reach a decision without him. I cannot see anything other than a conviction for contempt of court because the facts are too obvious. So the question just becomes what kind of sentence the court's going to impose. And if it does impose a sentence of imprisonment, then he will be arrested and imprisoned immediately.
Kathy, let's look at the history of matters in issues of contempt, which I understand are generally dealt with within the high courts. Is there a high rate of people that are being imprisoned after being held in contempt of court? And is there still another opportunity for the former president to be given a chance to go to the Commission of Inquiry and tell his side of the story after the Constitutional Court has had its hearing?
On your first question, I'm afraid I have to say pass. I'm not sure what the stats are. The point of a contempt of court ruling is also partly to get the convicted person to actually obey the original ruling. So I imagine that a fine would be a more popular punishment than imprisonment, but that's just a guess. On your second question, whether Zuma would still have a chance to go to the Zondo Commission, if he is sentenced to 2 years imprisonment, and that sentence is not suspended, then no, he will spend the next 2 years in prison. I suppose some special arrangement could be made to bring him from his prison cell to the Zondo Commission, but he's going to jail. If the sentence is suspended, and that is a common feature of sentences, the sentence is imposed, but it's suspended for a while, so it's not imposed immediately, on condition that the convicted person doesn't do it again. So that is a possibility. The court papers for the Zondo Commission even refer to it, that Zuma could be sentenced to 2 years imprisonment, suspended for what, let's say 1 or 2 months, on condition that Zuma comply with the original court ruling, which would mean Zuma would then go and speak to the Zondo Commission.
You've mentioned the issue of the review application that is before the North Gauteng High Court, and that has previously been given as a reason, even though not officially before the court, for why Zuma's legal counsel did not make representations in the previous case. Now, how much of what is happening at the Constitutional Court will also encompass that particular hearing and perhaps even some of the comments that the former president has made publicly? So what I'm asking is, will the court pay attention to anything that has not officially been brought before it?
Generally, the rule is no. We have an adversarial system, which means that the lawyers for the two sides present their evidence, and the judge considers only that evidence. There are some matters on which the judge will take what we call judicial notice, so something very, very obvious like the sky is blue. And I have seen, for example, in some of the lockdown cases, that judges do refer to current events. So it's not impossible, even though the general rule is no, they stick to the evidence brought. There may be some reference to media reports and general public reactions to what Zuma has done and said.
Does the former president have a case when he says that he needs the matter that is being taken on review to be heard before he can appear before the Zondo Commission of Inquiry? And just what are the options that the Constitutional Court would weigh up if that is brought to them as an argument?
No, he doesn't have a case. The time that it should have been brought to the Constitutional Court was when the Zondo Commission first applied to the court for a court order compelling Zuma to obey the summons. At that point, Zuma could have said, no, I don't have to obey the summons because I've taken the refusal to recuse on review. That would have been the time. It's too late now. But in any event, there seems to be a popular misconception that as long as something is taken to a higher court, everything stops. That's not how it works with review. If a matter is taken on review, as opposed to appeal, it's a slightly different procedure. The work of the body that's being reviewed carries on. And that's simply because otherwise you could stop anybody from carrying out its duties almost indefinitely, but certainly for 2 or 3 years. So the way it works is you have strict criteria for recusal. The person who refuses to recuse him or herself explains why against the rules. And then at that point, that can be taken on review, but the work of the commission continues. So the only way that Zuma could have got the Zondo Commission to stop working was either by bringing his argument to the Constitutional Court or actually going to the High Court to apply for an interdict to stop the Zondo Commission from continuing. And he didn't do either of those things.
Is it advisable for him to send lawyers this time round or for his legal team to make representations in this case?
I would strongly advise it, but I would have strongly advised it last time too. So it is possible that Zuma is not actually interested in what the court thinks of him, but is playing to some different audience. And if the court makes a more adversarial finding against him, which it's likely to do if it hasn't heard his argument, then he's got more of a ground to complain that he's a victim of some conspiracy. So legally speaking, of course he should send his lawyers. But politically speaking, he might be trying some other game.
Kathy Powell is with the University of Cape Town. Thank you so much, Prof, for your analysis there.